Hi, my name is Tom Gallagher. I'm the managing attorney at Gallagher Creek APC in San Diego, California. I wanted to share a few tips with you about forming a limited liability company in the state of California. An LLC, or limited liability company, is a flexible business structure that is particularly well suited for small to medium-sized businesses. It offers the company a formal business structure while still maintaining the limited liability benefits of a corporation, although with less rigid formalities to follow. Limited liability companies and corporations can trace their roots back to 17th century Europe and venture capitalism. Basically, what happened is that the ship owners would pool their resources together, typically in terms of monetary investments, in a shipping venture. And if the ship went out to sea and returned with goods, the company would split the profits among the owners according to the percentage ownership stake that each owner had invested in the company or venture. In the alternative, if unfortunately the ship were lost at sea, everyone would lose their money. However, they would not be liable for anything more than the investment that they had made in the company. In today's world, business owners typically want to form some kind of limited liability company or corporation so that they can limit their investment and therefore any kind of contingent liability in the business to only the amount of money that they invested or other assets they are willing to contribute to the company. Those assets then stay in the company, and the company can use them as collateral or to get other investors and to form the working capital that the company will need to manage its overhead, purchase inventory, what have you. And in the unfortunate event that the company is unable to move forward because its debts exceed its assets, the company would be able to dissolve, file bankruptcy, and the owners' personal stakes, such as a family home or car or investments, would not be affected, and the company would then be losing only the amount of money invested in the company. Another benefit of the limited liability company is that it doesn't need to hold as many records, board meetings, or have annual reports as a corporation would need to do. For example, a corporation needs to have a board of directors, which is basically a team of executive management that's going to have annual meetings and consider various proposals of the shareholders or other directors on how the business is going to conduct its affairs, enter into contracts, approve any kind of merger or realignment of the company structure, and determine how and whether to value the company and its shares so that company stakeholders can leave the company and be compensated for their stake in the business in terms of a fair market valuation. A limited liability company, on the other hand, might decide to set the terms of how it's going to be valued in the operating agreement when it starts the company. For example, if 5 friends went in together on a business and each owned an equal 20% stake in the business, they could determine that an accountant could come up with an appraisal of the company at a set time in order to set and establish a fair market value. That way, when the company decides that it wants to wind up its affairs and dissolve, it can easily do so. Or from time to time, if one of the members wants to leave the company, they can have the other members or a third party come in and buy those shares in the company and exit. An operating agreement will also be useful to allow the company to identify its members and the contributions of each members. Some members may contribute sweat equity by managing the daily affairs of the company, while others may only be contributing financial resources and rarely attend company meetings, but have a right to do so. The operating agreement will also establish compensation for the people who are serving as managers of the company and dictate who has what authority to serve as certain functions. When there are significant changes in the corporation, it needs to update what's called a statement of information. Statement of information is basically a document that you file with the state of California that tells them who's in control of the company, the major officers and directors of the corporation. So while a corporation will need to file that statement of information on an annual basis, an LLC, on the other hand, will need to file it only every other year. When ownership changes in an LLC, it simply needs to update its operating agreement to reflect those changes. A corporation would need to keep much more accurate records of stock ownership and transfer, and perhaps even vote on a new executive compensation package through the board of directors and have a vote or unanimous written consent of those directors before it can make major changes to the company. So as you can see, an LLC is going to allow you to have much greater flexibility in terms of the need to document and have formal votes on changes that you're going to have within your company over time. So a corporation might be beneficial for a company that's going to grow and take on new investors and potentially aim for even bigger goals, such as private placement memorandums and listing ultimately on a publicly traded exchange. Limited liability company is going to be very good for a small to medium-sized business that doesn't really ever want to grow into a share-driven enterprise. Also, a corporation is mandatory if your company is a professional company. And what I mean by that is that certain people by their profession are going to need to be licensed by the state of California, typically referring to what are the professions. For example, a doctor, a lawyer, an engineer, an accountant. Those people need to be licensed and regulated by the state of California, Attorney General's Office, Department of Consumer Affairs. They will need to only register as a professional corporation, and they have slightly different rules, although we can certainly help you with that if that is your particular circumstance. Under subchapter S of the IRS regulations, a small to medium-sized business that is organized as an LLC is allowed to have what we call pass-through tax treatment. With pass-through tax treatment, the company will file a nominal return and its owners, typically some sort of control person, will pay the business taxes individually according to their pro rata share of the business ownership. Typically, this needs to be elected within 2 months and 15 days of starting the business or at the start of the tax year in which you want to be treated as an S corporation or subchapter S treatment for an LLC. For more information on tax issues, our firm would be happy to refer you to a local accountant who could give you advice in terms of the specific accounting rules and regulations and any specific tax questions that you may have. As you can see, operating your small to medium-sized business as an LLC rather than a corporation will give you much greater flexibility and a lot less red tape than you would encounter running your business as a corporation. To get your California LLC or small corporation started, give us a call at 858-926-5797 or follow the link below. We can also help you draft and review contracts. You can see some of our other videos talking about the importance of including attorney's fees, choice of law, and form selection into your agreements. You also may want to consider having arbitration clauses or mediation. We go further into that in some of our other videos and why that might be helpful to you in avoiding further conflicts or quickly and easily finding a resolution to those problems when they occur. Thank you for watching this brief informational video. I hope that you found it informative. If you have any questions, please don't hesitate to give us a call 858-926-5797 or follow the link below. Thanks for watching.